Hello everyone and welcome to the second of our video tutorials on the civil system, and this tutorial is looking at the civil procedure before the 1999 reforms which were brought in by Lord Woolf. For the exam, it's important that you have some understanding of how the civil procedure rules have changed due to major changes that were made to the civil justice system as a result of a report that was made in 1996 by a judge called Lord Woolf. And this report was called Access to Justice. And it came about because in 1995 there was a survey carried out by the National Consumer Council which found that 3 out of 4 people who were involved in serious civil legal disputes were dissatisfied with the civil justice system. And it was found that out of 1,000 respondents, 77% believed that the system was too slow, and 74% said that the system was too complicated, and 73% said that our civil system was unwelcoming and outdated. And a lot of these respondents were referring to the fact that there were 2 totally different processes for if you were bringing a case in the High Court, where you followed what was called the White Book guidelines, which started with a writ, or if you were bringing a claim in the County Court, where we were following what was known as Green Book, and the case started with a summons. So the civil system in the early 90s was being heavily criticised as being too complicated, too slow, too expensive, and it needed to be modernised and brought up to date. So because of all this criticism, Lord Woolf was appointed to carry out a review and overhaul of the civil justice system. And he was tasked with looking at the problems and looking at ways of tackling them. And Woolf wanted to eliminate the defects in the civil justice system, which I've listed below. These were sort of the key flaws that he identified, in that the system was very expensive, there were huge delays and backlogs of cases, the system was very complex, as I mentioned before, totally different rules depending on the court. It was quite adversarial and daunting to the claimants wanting to bring a case, that it could be quite an unjust system, so unfair. There was quite a heavy emphasis on looking at how experts were being used in court. So it was heavily criticised, and these were the key problems that Woolf identified. So Woolf completed this 1996 report, and it was published. And proposals resulted in the Civil Procedure Act, which created the Civil Procedure Rules 1998, which you can see here came into effect in 1999. And they made some huge changes. And some of the key changes that Woolf introduced was a simplified procedure, which we're going to look at in our next video tutorial, to try and make the process simpler for people so they knew how to start a claim. Pre-action protocols, case management, ADR to be encouraged, and also a focus on looking at what sanctions would be given as well. Pre-action protocols here were one of the most important things that Woolf introduced, in the opinion of lots of people. A pre-action protocol was to try and encourage people to exchange information early on in a case about a prospective claim, and to try and avoid litigation by promoting settlement. So Woolf was actually very much focused on trying to get parties to settle. So having pre-action, meaning before you go to court, process. So sharing all the evidence between parties, looking at ways of settling. Case management was also introduced by Woolf. And the idea here was that the cases would be controlled by the judiciary rather than leaving the conduct of the case to the parties. And the idea with that is that if judges were managing the cases, that would help cases to come to trial quickly, more efficiently. And this would mean that litigants, parties to the cases, were having less control over the pace of the case than in the past, and that cases should be subject to a timetable so that individual parties couldn't draw out proceedings, cause delays. And in the past, that was a real problem where one party will basically drag their feet, drag it out. And the courts wanted to avoid that. So now judges were going to be in control of the timetabling. Alternative dispute resolution, also known as ADR, we're going to look at that in quite a bit of detail later on in this topic. And Lord Woolf, in his final report, urged that people should use alternative dispute resolution. And that just means that parties should be encouraged to try to use any other method, basically, other than going to court, and only use court as an absolute last resort. So we're going to look at the different types of alternative dispute resolution that parties can try before actually taking their case to court. So this all sounds very positive then, the changes that Woolf made, and it is the Woolf reforms, that have resulted in the procedure rules that we follow today. And there have been some good changes. Some of the things are very good, but it has been subject to criticism as well. So for the exam, you need to be aware of some of the criticisms. You could potentially get asked a question. Remember, this would be on section B of the exam. So you could potentially get a 15-mark question asking you to analyse and evaluate how successful the Woolf reforms have been. And the Woolf reforms have been heavily criticised, particularly by Zander. And I've given you quite a lot of detail in your booklet about the criticisms that Zander has made. And I've bullet pointed some of these key criticisms that have been made on the slide here. So in your notes, it'll tell you all about the front-loaded costs, parties being subject to costs at the beginning of the case. And this will particularly affect people who were settling outside of court before the trial actually started. They'd already paid lots of costs towards the trial. In terms of case management, that this has actually increased costs because it generates more work by lawyers. And according to Zander, the new rules encourage inconsistent decision making because people have little idea how much they're going to recover if they win, how much they'll have to pay if they lose, and that judges actually vary in their approach because when they're looking at the overriding objective, which is what the judges use as part of case management, judges are given a lot of discretion there. In terms of ADR, Zander said that there wasn't evidence that this was being enforced at the allocation stage, and that Zander actually recommended that there should be penalties for judges who weren't actually enforcing the requirement to try ADR. And Lord Briggs, someone else who was quite critical of Woolf, proposed that there should have been an online court for claims of up to £25,000 because, in his opinion, that would solve a lot of these problems. So I'd encourage you to read and highlight your booklet, your notes on the Woolf reforms, and also look at the additional articles that are on solar to make sure that you're able to answer a question on whether Woolf has improved the system. And I think the bottom line is the civil procedure rules that we have now as a result of the Access to Justice report are an improvement, but they're certainly not a fix-all. There's still a lot of problems with the civil system. In our next video tutorial, we'll be looking at how a claimant actually starts a case using an M1 form, and we'll look at the 3 tracks that were created as part of the Woolf reforms and how these tracks help us to allocate civil cases to the right courts.